Welcome back to the Wealth Actually podcast, the show that features experts, entrepreneurs, and commentators that will give you the right knowledge, planning, and guidance so you can preserve your assets and enjoy your wealth. Learn more and subscribe today at wealthactually.com.
This podcast is for educational and entertainment purposes. It is neither investment, legal, nor tax advice. It does not represent the opinions of the employers of the host or guest.
I'm Frazer. We're going to talk to the Ragin' Cajun of estate planning, Paul Hood. We discuss the new Delaware Wellbeing Trust, its features, and some of its drawbacks, and things that we can think about going forward. Welcome aboard, Paul.
Great to be with you today.
The Delaware legislature has tried to give us some new tools to give us a holistic approach to planning for trustees and for beneficiaries. Help us sort of think through first, from a function perspective, what trustees do. I always thought of it as, they held assets for the benefit of beneficiaries, and then with that, they have to administer them, they have to invest them, and then they have to distribute them. Have we got that about right?
Well, I've always had a broader view of trustees. Jay Hughes, a good friend and fellow pilgrim in this field, he talks about the trustee as a personne de confiance, and like a trainer, an elder. And for a lot of beneficiaries, and I believe trustees, especially in discretionary trusts, the trustee needs to be that. There needs to be some attention to the person of the beneficiary, not just the finances. Send us a budget. The distributions committee, who's in secret, will meet and we'll decide how much we'll give you. Well, I think a trustee's duty is broader than that. Or let's say this: you can meet the minimum requirements of being a trustee by doing what you said, but I think the very, very best trustees are personnes de confiance.
No, I agree with that. The problem is identifying the people who mix the temperament and the talent and then paying for them. So to that end, with those different functions, the world of bifurcation came about. Directed trustees, where people got to be good at certain things. Maybe you had a good investment person, you had someone who was with the family who understood the dynamics from a distribution standpoint, and then the administrative side, making sure the I's are dotted and the T's are crossed as far as the administration's concerned. How do you view that in the evolution of the trustee function?
It's interesting because I haven't been in practice since, the 20th anniversary of Hurricane Katrina is August 29th of this year. My life changed that day. I didn't know it, but it did. And I left Louisiana. So I haven't practiced law in 20 years, but I remember the directed trust percolating up, and it was driven by the investments. People wanted the bank or the institutional trustees, but they hated their investment performance. So the compromise was, okay, we'll reduce our duties, because the bugaboo was always whether it was a proper delegation of investment authority. The trustee could still be held liable if the court thought it was an improper delegation, okay, or oversight of the delegation. They started out investing right, but then they got real heavy in crypto and foreign flips. So you can go there. So no, we'll take fewer basis points, but we don't have the liability for that. That liability, it's not delegated. We have segregated it, okay? But enter the Wellbeing Trust. Well, and this is only true in Delaware in the Wellbeing Trust statute, because it's an opt-in. But once you opt in, the trustee and all the advisors are required to perform provide those well-being services. Now, the question is, who is responsible for providing them?
Well, let's step back for a second. The well-being provision, which is designed to give the trustee the tool to promote improve, advance the well-being of the beneficiaries, which I think we can agree is a good thing in concept. What do we think of well-being as being? How is it defined? And what part of the function is it taking from the trustee's perspective?
I'm going to default back to, I think it was Potter Stewart that said he knows pornography when he sees it. I think that's the same with well-being. Things are either obviously well-being related and are not. And there's a continuum of them. But the whole concept, I think it's just pretty much to promote the betterment, the improvement, just the maintenance, personal maintenance of a trustee. I mean, of a beneficiary.
So how do you think about it from a trustee's perspective when there are multiple beneficiaries and maybe the well-being for one is not the well-being for another? Very often a trustee has to balance a lot of different equities, and I don't mean that from a stock perspective, but sort of taking care of one, possibly at the expense of the other with the trust's assets. How does the new statute in Delaware address that?
Well, and you raise an excellent point. And what you said, you were talking about equities, okay? What it really is the trustee's duties. And the big one is the duty of impartiality. Arguably, the 3345 statute, and I'll call it that, that's the well-being statute. That's the opt-in. They have another one, and it is to provide, it's an immediate power. It was added to 3325 as number 32 in the Delaware Trust Code. And it allows almost the same things. It empowers trustees, now not the advisors. Okay, it doesn't say anything about the advisors in that statute. Whereas 3345 includes, and remember in Delaware, an advisor is like the trust protector and the administrative trustee, that kind of thing.
Right.
They call them advisors. I don't favor that language because I believe that they should all be fiduciaries. So I call them trustees because I think in the end they're going to be held, especially if they're professionals, they're going to be held to that standard as it is. But that statute was immediate when the law was signed, when it went into effect. So they're authorized to provide those services now. And for me, I would never opt into that statute because why do you want to take on a mandatory duty that's unclear?
Yeah, it sounds like a Roach Motel where, you get in, but you can't leave. And
Eagles Hotel California. You
that's
can check
right.
out anytime you like, but you can never leave.
That's right. So if you were to encounter one of these trusts in the wild and you've got multiple beneficiaries, but let's say 3, one of them needs a lot of help, another one could use the help, and then the other one is completely self-sufficient. How do you sort of build a process around that so that you are being impartial, but you are invariably taking away from potentially the corpus of the trust in order to effectuate different goals as they develop for these beneficiaries?
Well, it obviously starts with the settlor's intent. And it's the settlor's intent first as set forth in the instrument. However, because this is not a court case where you're construing, because I used to be an expert witness, construing, problematic clauses in operating agreements, trusts, wills, whatever. You construe that, including more information, you investigate. The trustee, let's look more, because you look at the language and, well, it would authorize it here, but let me find out a little bit more. If the settlor is still alive, I would, at a minimum, also talk to the settlor, okay? And also, if he or she is not still alive or sentient, I would investigate. I would talk to other people, and I would make that into a process so that when you're questioned down the road, so here's my process. Anytime you have a process, you're better off. And I tell people this, when all that planning was done in 2012, and we filed more gift tax returns, I was the only guy in the country saying, don't put your marginal wealth clients into anything big, irrevocable. I said, because I think this is going to work itself out. And for 6 hours, I was wrong on January the 1st, 2013. But there were lawsuits. And Jackson versus Cologne was one of the cases. And poor Cologne, the lawyer, got sued because he didn't have a process for evaluating whether his client had put too much or had retained sufficient assets after they did this planning. So it's all about a process in the end. So instrument, Settlor, and I would investigate and I would wrap it up into a process that was documented.
So if I'm a clever beneficiary, I look at something like this, and maybe if there is a HIM standard, which made it imprudent maybe for the trustee to disperse assets to me, I might go to a well-being component of a trust and say, well, maybe this is something that I could petition the trustee for assets. Is that an area of concern for you, or is this something where those are two different things entirely and therefore not particularly related?
I think the latter. Well, first of all, obviously every beneficiary trustee relationship is different, and it's governed first by the trust instrument. What is the beneficiary entitled to from a standpoint of distributions? Do they get an annuity? Do they get a unitrust amount? Do they get income, fiduciary accounting income? Are they only a discretionary beneficiary of principal and or income? You have to look at all of that. So if it's something that isn't covered, well, then, the answer is probably no. Because while I think that the well-being provisions are similar to HIMs, they're not identical. And that would concern me. And that's, if I was drafting it, I would not allow the trustee, if it was subject to a HIM standard. And I'm not a big fan of HIM standards. I think they expose you to asset protection, problems. There are a lot of things. And I'm just not a fan of it. I like wholly discretionary trusts or unitrust, annuity trust distributions, easy or hard, that kind of thing. So for me, and particularly if it's an interested trustee, I would define it so it cannot, whatever well-being power is exercised stops at the HIMS line, the HIMS county line. It cannot cross over. Because then you've got a state, of course, if there is a state tax problem.
Right. No, and to that end, I was thinking about this as we were sort of leading up to this today. And, from a prenuptial planning standpoint, I would think the well-being clause would frustrate sort of prenuptial planning with regard to the assets of that particular trust, because a good family lawyer would take a look at that and say, well, yes, there may be discretionary elements that the trustee has, but overall, if the well-being sort of transports not only to you, but maybe the rest of your family / kids, that should be part of the negotiation in a divorce settlement. Is that something that's popped into your head, or am I fantasizing poorly?
Well, no. I think you're on target. Here's the problem. In a wholly discretionary trust, if you opt in under 3345 to being a well-being trust, your duties to perform well-being or provide well-being services are mandatory. Okay? Doesn't that undercut the wholly discretionary nature of the trust? And I don't see how it doesn't. Do you?
No, if it's mandatory, if it's shall versus may, those two words are important. They're important in other parts of law too.
Well, the statute uses shall.
Yeah. I agree with you then. If it's mandatory does a lot of things to the word discretion for a trustee's perspective. So, point taken, to be sure.
I can tell you this. If I was running a Delaware trust company today, First thing I would do is I would never opt in to 3345. Not until the legislature fixes a few things. The directed trust, making sure that clarifying who's responsible. So if you have an administrative trustee and a distribution trustee and an investment trustee, the investment trustee is probably not going to be involved, okay? It's going to be one of the other two, and it's going to depend on what the service is and how it's treated. If it's treated as distribution, I would argue that the distribution advisor is the one who has the duty and the liability. But their statute right now does not protect, or at least the 3345 statute does not protect those in that bifurcated arrangement. All we did when we started the whole idea of this type of trust is to basically segregate, because trusts are, the bifurcation of legal and equitable title. Beneficiaries have equitable title, the trustees have legal title, and the duties. And we've just subdivided legal title and those duties. But in the statute, they all seem to get melded back together, commingled in a way.
Sure.
So I would not, for a directed trust, there's no way. I mean, the trust instrument would have to be so beefed up to make sure that was clear, that despite what the statute says, here's what our deal is. But I'd feel better if they changed the statute.
So as a practical matter, anybody who takes these roles on, takes on, with great power comes great responsibility, as Ben Parker told Peter Parker. You get these incredible amounts of power and responsibility, and therefore liability. As a practical matter, if someone has to mandatorily deal with the well-being component here, whether as a distribution advisor or as a full trustee, how do you get around that? I mean, how do you know that you're picking the right advisors, or not subjecting beneficiaries to, the drug addiction industrial complex or the psychological industrial complex? And maybe a better way to put it is, if you get going and you've made a mistake, how do you fix it? Or can you turn it off later if the problem is solved, but you have a mandatory duty for well-being?
Well, and that's a great question. And your comment about the addiction complex, I call most treatment programs 28-day spin cycles, because and that's why the rate of success is so little and so low. So I get that. Yeah, how do you turn it off? And what do you do if a beneficiary says no, thank you?
Yeah, that's a good question too.
I'll give you another one. I'll give you another question.
Mm-hmm.
What if 5 years from now you've opted in and a beneficiary says, I've been damaged because you should have provided me this service 3 years ago, and I'm going to sue you or try to remove you for breach of your duty to provide those services because you didn't guess right.
Right.
And I think that gets to your concern about all this.
Sure.
How's the trustee going to know? Right.
Well, and, knew or should have known. And then, what happens if the beneficiary lies to you, which happens in tough situations like that?
A lot.
It's just a brutal one. I look at that and say that, when that function is melded with larger funding and distribution functions, I come to the conclusion, okay, why wouldn't you have a separate trust? If the grantor wants to provide for the well-being, why wouldn't you endow, let's call it a self-improvement trust or something like that, with extremely limited functions and distributions, and segregated from the bulkier assets, so that you aren't mixing those functions and creating a real quagmire for the trustee to navigate, when they're worried about selling the company on one hand and then taking care of this on the other. Is this too many functions delineated in the setting that we're providing here?
Well, I just did a webinar for Lineberg with Jocelyn Borowski from Duane Morris, who's written about well-being trusts, and she and her partners and firm have been involved, probably were involved in the committee drafting. I think Todd Flubacher was on that committee. That is, she made that point that you either could cull out a part of a trust that is limited to the well-being, or you create sort of a sidecar well-being trust.
Right.
And I think that's a good idea. One thing we did not get to, and and it really slipped my mind to ask, and you're obviously much closer to Delaware than me sitting over here in Michigan and close to Motor City. Are trustees doing anything about this? Are they implementing these types of programs?
From my perspective, yes. So I think trustees are being asked to fund or take assets and fund a variety of things, whether health or beneficiary education programs, governance programs, things like that. And the short answer is yes. I think that happens all the time, and I think that's folded into some of the distribution provisions. And I think if I haven't seen this specifically, but if I were a good trustee, I'd want a note signed by the various beneficiaries that are participating in this, saying that we're doing this to provide an improvement in this or that, and we're doing it in a way that is meant to further family goals sort of set out by the grantor somewhere. But I don't know of any corporate trustees that are doing this, other than maybe as an add-on service that is separate and apart from their trustee function, which I bet they probably take great pains to put up firewalls so that the decision making on the fiduciary side is a little bit different from the service provision on some other side.
I think that's probably right. Again, right now, if I was a Delaware trustee, it would be no opt-ins, and even if you wanted to opt in, never on a directed trust, which now most trusts are.
Sure.
About almost 30 years ago, I spoke to a national group of trustees of a bank that is no longer here. And I told them, if y'all make the mistake of going to 1-800-TRUSTEE and quit making the hard decisions, you're going to go the way of the dodo bird. There were about 400 of them in the room. And they looked at me like deer in the headlights. And I was right about them, because that's essentially what they went to, and then they went down. So, and this was a big national bank. So these are the times that try fiduciary souls. And
fiduciary insurance providers too. I mean,
that's exactly right. And you had mentioned about could you get out of it? Could you change it? Well, one obvious way is a non-judicial settlement agreement. We all get together and we force King John to sign the Magna Carta on Runnymede. We just we go from there. But I can see accountings going forward, when they ask you to, sign off, there's going to be a well-being accounting. And it's going to include things like, okay, here's the services we provided, here's the values, blah, blah, blah. And that's all the services we believe you need. And if you need something else, you need to let us know. In other words, I'd try to flip as much of it back on the beneficiary as I could.
Oh, and when you open up the idea of qualitative benchmarking to the trustee function, if I'm wandering into a trustee situation personally, I'd be going, no thanks.
Right. Because you can't quantify your risk.
Hence the term qualitative. There's no amount of money you can pay me to try to guess that I'm not going to get sued 15 years from now.
Well, you're exactly right. And I think that's where they ultimately are going. I don't know, because I haven't been able to investigate and Columbo the information out yet. Because I will go back. Pardon me, I got one more question for you. What I want to know is what prompted them to think they had to act then with a quickly enacted law. And my suspicion is the big banks, they all have their upper end concierge service. I think Wells Fargo's Abbott Downing, Ascent, I think is U.S. Bank. And those groups, Merrill has their own. Those groups have PhDs in family psychology and wealth psychology and everything else. They're providing those services now to their people. And I think the Delaware trustees want to make sure they don't miss out on that train. But with that comes a lot of a liability, as you said.
Well, they had to find a way to pay for it. Those services aren't cheap. Those people are expensive. And invariably, the trust tends to be a pot of money to compensate for that. And maybe the only pot of money. And if it's unclear whether that's an allowable distribution, I mean, that to me, I agree with you. That's probably part of the reason they did it. I think there's a good reason they did it, which is ultimately providing another tool in the toolkit for the trustee to, help with the long-term well-being of the beneficiaries. But as we've gone through a lot of different references before, the road to hell can sometimes be paved with good intentions here. And I think we probably agree that there might be some better precision with the drafting here that could make this a better tool for everyone involved.
Well, I will tell you another area and Jocelyn agreed with me on this. If you read the Delaware's version of the old UPIA, because it's been now replaced with UMIFA, if you look at their law, it's unclear where those well-being payments, whether they're deductions or distributions, are to be who they're to be charged to. And if you look at the new UMIFA, those services would be 100% charged to principal. And Jocelyn said, under Delaware law right now, then this is something she agreed that they needed to change. Those services are all 100% chargeable to principal under current Delaware law. And so that's another area they need to change.
Crazy stuff.
Let me also go back to something that you mentioned about turning it off. Okay, well, obviously, besides the NJSA that we talked about, there's also the possibility people say, oh, we'll just decant it out. Well, be careful before you decant, because people are getting bad news in state. I've seen 18 adverse decisions in the last 3 years in state fiduciary duty actions. And they've involved more than just the trustee. A lawyer in an Illinois case got zapped by his malpractice carrier in a decanting. They said it was an intentional tort and excluded from coverage.
Yikes.
Another lawyer got disciplined for an improper decanting. So, but people are saying, oh, this is easy. Just pour the bottle in, new trust. It's not that easy.
Traps for the unwary. Paul, great stuff. Let's pause there because we could probably go on for 2 more hours. How do people find you and your writings?
Well, I have a lot of webinars and articles at linebergservices.com. My website, paulhoodservices.com, has a lot of my latest articles, as well as some real interesting checklists. One of the best client development tools that I've ever seen, and I developed it, but it's for free on my website, is my buy-sell options grid. And there's a lot of other stuff there. My email is paul@paulhoodservices.com. I get questions from people mostly all over the country, but occasionally from foreign countries. And I always respond. So
great stuff. And go Tigers. Go GEAUX.